There we go. So, confront and cross-examine. So, the right to cross-examine component, you're the defendant, and the prosecutors asked a bunch of questions of the witnesses to try and prove that you're guilty, right? And you're sitting there going, oh, this is ridiculous, because they're presenting everything in a way that's favorable to the state, to the prosecution. So what do you want to do? Now write this down. You can do this. Actually, going back to the this one, you can defend yourself. You actually can be your own attorney. Although even somebody who is an attorney, the old adage is, an attorney who represents himself or herself has a fool for a client. Did you catch that? In other words, it's really good to have somebody who's like separate and kind of looking in objectively on the case and so forth. But nevertheless, you can do this. And in fact, there was a case where a guy was charged with murdering a bunch of people on a public train. And he refused a public defender. He could have gotten one. He was poor. He refused it. He's like, I refuse a public defender. I'm going to defend myself. I will act as my own attorney. And during the trial, it was really weird, he got up and he did the cross-examination. He got up and he asked his questions of the witnesses that the prosecution had on the stand. Did he do a very good job? No, he did a horrible job. And it was really weird because the last time that those people had actually been in that close proximity with that particular man, they were on a train and he was shooting people. Did I shoot you? No. I think it was really weird. It was messed up. It was like he had a racial animus. He hated white people. And so he didn't kill black people. The black people were testifying against him because he was shooting all the white people on the train. He was found guilty. But nevertheless, okay, you got that? Shh. You have the right to cross-examine. Now, let's go to the next part. Okay? Oh, and here's the thing. Here's the thing. This is where the cross-examination part and the confrontation part run into some difficult situations. We'll get right to it on the confrontation part. You ready? Here we go. The right to confront a witness, slightly different than cross-examination, although they end up being kind of similar. The right to confront means you're the defendant. You have the right to be in the same courtroom as the witness who is testifying against you. So the idea is sort of like if you look at them eyeball to eyeball, then they're more likely to tell the truth. And they won't lie if they're in the same courtroom with you. Although, you ready? Write this down because I'm going to get right to the exceptions. Some witnesses are very vulnerable. And courtrooms using modern technology have created some buffer zones for those witnesses. So for example, if it is a rape victim, she may not be willing to testify if she knows that she's going to have to be in the same courtroom with the alleged rapist. So do we want to discourage rape cases from actually being tried in a court of law? Not necessarily. So can we uphold his Sixth Amendment right to confront that eyeball-to-eyeball part while still providing somewhat of a cushion safety net thing for the witness? Because they still want to testify. A lot of courts are doing this, two-way camera things. Got that? In fact, actually during COVID and Zoom and so forth, to the extent that those are deemed okay, that's kind of the way it is. So you can look at them face-to-face through the barrier of a two-way camera. Does that make sense? So those are examples of things that have been deemed to be not a violation of the Sixth Amendment right of confrontation of the witnesses. Okay? Here's another one. Child victims. For similar reasons, they may be not very excited about testifying on the stand when they're too close in proximity to the defendant. Okay? Where it really comes up is if the person, the witness, is not available. Okay? Where the witness is not available and the prosecution wants to get into the court, have the jury hear something that person said. Can they do that? Well, first of all, let's identify what is it when somebody says something, somebody else hears it, And then that person who heard it, they want to come into the court and say what they heard. It's called hearsay. Write that down, hearsay. You can see it in the handout. We've got the, if you go down, we're right to confront and cross-examine witnesses, and then we have no out-of-court hearsay statements allowed. So the general principle is, look, it's kind of like Connor is the victim, and he's like, I don't know, who's the perp? We need a perp? We have a volunteer perp? Okay, okay. Caden's got dibs. All right, so Caden, so here's the scenario. Caden shoots Connor, and Connor is like, and then Connor turns to Gabe and says, hey, Gabe, Caden shot me, okay? And now, so here we got the trial, and we want to put on evidence that Caden shot Connor. Well, hello, we should put Connor on, because Connor was there. He can be an eyewitness. We can cross-examine Connor as in, where were you looking when this took place? How do you know? Cross-examination questions, right? We can confront that. But if we try to bring in Gabe to say, oh yeah, I heard that Connor said Caden shot him, that's no good. Most of the time. You ready? Here's some exceptions. You ready? What if those were Connor's last words? They were his last words. Those were his dying utterances. Whoa. Ooh. Should we allow that in? Courts are going to allow the dying words because there's deemed to be some veracity, some truthfulness, supposedly in the last words that you say. Will that be the case in your life? Who knows? But in a court of law, if the last words are, Caden shot me, Gabe can come in and say, I heard Connor. His last words were, Caden shot me. Okay? Anyway, whatever. I mean, you can bring up all the evidence and so forth that he didn't know what he was talking about and it was a disguise and blah, 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 blah. But that is an exception to the hearsay rule. All right, next one. Okay, you ready? There is also called the excited utterance exception. I've got that one listed as well. It's kind of a similar idea. So let's say that Connor is shot, and he's like, I got shot! Caden shot me! And then he goes into a coma. Okay? So it's not quite the dying utterance because he's in a coma. But it's kind of like that excitement aspect issue thing. We may let those statements in. Even though we can't confront the person who said it. We can't cross-examine the person that said it. You got that? Do you follow that? Okay, those are some exceptions to the hearsay rule. You go to law school, you're going to spend lots and lots of time, lots of time talking about the various different exceptions to this. So we got the excited words, we got this one, we got the vulnerable witness, the excited utterance. Okay, now, let's get to this one, because this was a really, really horrible case. And I remember this case because way back when, this was a case from 1990, and actually started earlier than that. Okay, in the late 80s, here's the facts. Okay, it's ultimately going to be a United States Supreme Court case. It's called Idaho versus Wright, and he deals with this situation. You ready? Here's the facts. Oh gosh, we just have enough time. Whew. Two little kids. I mean little. I want to say like maybe 2, 3, 4 years old. Two siblings. Sexually abused. The Boise police were saying that the two kids, and they ultimately did bring charges against the mom and her boyfriend, okay, for sexual molestation. In the trial, they wanted to have the kids testify. The youngest one, was too young to be able to actually coherently, effectively get on the stand. I mean, could you? And describe what was going on? The one who was a little bit older was also not in a position to be able to effectively testify on the stand in a trial. Even if he did put the barriers or anything like that, it's just like they're too young. They couldn't count on it necessarily. So you look at that and you're like, well, what are you going to do? Dismiss it? Sixth Amendment? This is critical evidence. Because here's what had happened. The older of the two kids had said something to her doctor about a number of things, including things directly associated with the criminal conduct. I don't want to get into all the details and so forth, but the sexual violations on her. You understand that? And she also said some things that we refer to as corroborating evidence. Now, make sure you have that written down. Facts, statements about other sort of neutral things like what was in the room, what did things look like, things that you could look at and go, well, that's true what she said, that's true what she said, so therefore it's not all this make-believe. Maybe we can say that it's there. Maybe we can feel like this is a hearsay statement by this kid that we can bring in because, oh my gosh, do you think the prosecutors wanted to put the doctor on the stand and hear what the little girl said to the doctor and have the jury hear that? Yeah, they did want to. And they had other corroborating evidence as far as physical things that had happened to her body. They wanted to tie all the pieces together and say, yeah, those two people did it, the mom and the boyfriend. The defense obviously objected, violation of the Sixth Amendment. The defendant doesn't have a right to confront, to cross-examine the witness. The case went all the way up to the Idaho Supreme Court. I was a clerk for my justice at the time. It was a split decision. My justice, who I agreed with, was on the dissent. He was in the minority. The majority of the Supreme Court for Idaho ruled in favor of the defendant, saying that they could not bring the case with that evidence. They were going to throw out the evidence. Thankfully, though, the state of Idaho appealed it, and the United States Supreme Court accepted the case for review, and they reversed the decision. They said that there was enough corroborating evidence. They sent it back down. They had the trial. Ada County prosecutors did the trial, and the two adults were convicted and sent to prison. Booyah! I helped write the dissent for my boss way back when. Yeah. I mean, yeah, he's the judge, but I did my job too. All right, so wipe her down. Did we get? Oh, we're good. We got some new fresh ones there. Next time, you have the right to remain silent. Anything you say can be used against you in a court of law. You have a right to an attorney. If you can't afford one, one will be appointed for you. The Miranda rights.